Constitutional Development Department is giving an update on the progress made in litigation in the Marikana case.
Only lodged one claim. And that claim, as we speak right now, had been finalized. And this has been our stance since 2021, that we paid 3,995,121 plus costs in relation to that matter. And then SIRI has taken up the cause of families associated with 36 deceased minors, with 34 families securing settlement for loss of support amounting to 71,230,491 rand. Notably, SIRI has introduced the novel concept of constitutional damages, which is a new head of damages. And I think this is what we are going to be seized with, because the residual issues that are actually being dealt with on behalf of SIRI relate to this novel issue of that is called constitutional damages. It's new. It raises a number of issues. It raises emotional damages and a whole lot of other aspects. But for the record, we have paid via SIRI or under the auspices of SIRI 71,230,491, and I need that to go on record because that's what we paid for. And then we have paid through Maluleke Msimang attorneys, and they've actually been able to secure settlements for 15 of the claimants. And the total amount that has been paid to Maluleke Msimang via their trust account is 77,034,643.70 for the record, representing the 15 claimants. There is no straight quantification, a straight line quantification of those amounts. The amount might be varying on the 15 claimants. However, the quantum that we've paid to that law firm in relation to these claims is as I've already outlined. And so I think outside of those 15, I have not been given any other additional individuals that were represented by Maluleke Msimang beyond the quantum that we paid or committed from the state, which is taxpayers' money, in the sum of 77,034,643.70. Tlatla attorneys dealt with or handled matters relating to assault and gunshot. Progress is underway with certain claims still undergoing verification. But those claims, I think Mr. Chowe can speak to, because those are residual issues that needed to be dealt with. In relation to that law firm, we have paid through its trust account 51,803,863 rands and 66 cents. The last law firm that in fact was representing claims and have managed the interests of two distinct categories of plaintiffs, those that were arrested and those that were detained. We have in fact, as the state, utilized taxpayers' money in the sum of 102,305,000. It's a straight line. 102,305,000. And that, in fact, is in settlement of 10 of the 12 matters that they've lodged with us. Now, where are we? The total amount that we as the state have committed, the aggregate total amount is 330,445,630 rands and 37 cents. And this has been disbursed to the legal representative mentioned above. That's the figure that in fact appears on record. That's the figure that has been audited, and that's the figure that we stand with or about as we speak right now. And these funds have served to address a spectrum of claims that related to legal consideration stemming from the Marikana incident. I repeat the amount. The total quantum that the state has paid thus far is 330 million. 445,630 rands and 37 cents. I now deal with the issue of the because it's reported widely. I think I also saw a report yesterday that the state is vacillating, dilly-dallying, and not actually dealing with the rights of the claimants meaningfully. I must actually indicate that from where I sit, except for one or two matters where quantification still needs to be worked out, which in fact will add on to the globular figure. We, as I've already indicated, are creatures of instructions. Where a new concept as the matters stand now is introduced, such as constitutional litigation, which was not existing as at the time when the incident happened. You are finding a situation where you are applying the law retrospectively, and we need to get instructions from the South African Police Service and everybody else. And we are actually having to deal with the issue of what is this concept of constitutional litigation. Why was it not pleaded as and when the matter started? And as creatures of instruction, where do you then derive the powers to settle on an aspect using taxpayers' money, which has not been ventilated in court? And for all intents and purposes, until and unless there are new developments and there is cogent argument that is presented before any court of law about any novel or a new issue that arises out of the Marikana litigation, I think we have done enough. And the question that needs to be asked is, how long is a piece of string from where we are? And I've already, in fact, indicated that our mandate is only to deal with management and coordination of a litigation relating to the Marikana incident. I don't have any further mandates as matters stand, and should the court decide that the issue of constitutional damages, which in fact is being preferred by Siri, and I've actually sat with them, and this is an issue that arises from the life Esidimeni issue, when former Deputy Chief Justice Museneke actually lifted that issue. It was not there as and when the Marikana incident happened. So we need some intervention insofar as that issue is concerned. But that intervention is above our pay grade, and we are not going to invent a new issue and hope that we'll get money to pay in respect of that particular issue. And that is where we are as at the moment. In culmination, remarkable strides have been realized in the strategic orchestration and harmonization of the Marikana litigation. This is our statement as we speak right now. The resolution of numerous claims stands as a testament to our unwavering commitment to justice and due process. However, the introduction of the constitutional damages concept, as I've already alluded, is something that we do not actually have instructions for. The papers have not been amended such that we can actually go to our principals and say, here is a new novel issue that you need to budget for, and therefore it is actually above our hands. It is a concept that is introduced and deals with residual considerations, inviting contemplation of the crossroads of the law and ethics. And to the extent that it in fact elucidates the crossroads of law and ethics, we don't have instructions in relation thereto. But it is an issue that we are prepared, upon instruction, to explore. And ladies and gentlemen, these are intractable landscapes that we are dealing with. I've already indicated how much we have committed from the state. And I will, DG, leave it at that, on that note. Thank you very much.
Thank you very much, Solicitor General Pedisani.
As we'll leave it for the moment with government giving a response on the Marikana litigation of over 229 claimants, and in response saying that reparations to the claimants of over 330 million or so have been paid, and that government is committed to justice and also redressing the circumstances that took place in the Marikana massacre. But that's where we'll leave it. From myself, Cindy Mabi, and the technical crew, thank you so much for joining us.